Hey guys, embarrassed to say I just got caught strumming along to a Tom Petty song playing on this record player behind me with this little army man when I really have no idea what the heck I'm doing on this guitar, and this guy unfortunately can't even defend himself against it. But on the subject of defense, self-defense with a gun, which this guy actually has, but he's plastic. It's a bit of a problem for him. We are covering today Part 10 of our series on self-defense for Need to Know What, Need to Know the Law. Dave McDermott here, McDermott Law Group, McDermott Mafia, McDermott Militia, all one of the same. Guys, where we left off on the last Need to Know is we just finished up with arraignment. Basically, you've just pled not guilty. You've just demanded discovery from the state, and your case is really legitimately underway right now. And when I say legitimately underway, this is the meat of the case. This is basically the back and forth of the exchanging of any and all evidence that either of the parties have. And the state, as I told you previously, has to turn over, the prosecution has to turn over the evidence that they intend to use against you, any evidence that they've actually accumulated throughout the course of the investigation by the police or anybody else. And the significance of this, by the way, when I say any evidence, even evidence that's potentially helpful to your case pursuant to law, they're supposed to turn over. And by the way, when we're talking law, we're still dealing with the state of Illinois for purposes of the self-defense series, and we are dealing specifically with Cook County and Cook County rules, because some of those rules vary from county to county here in Illinois, and from county to county in other states as well. But with respect to discovery, as I told you, discovery is all the evidence. I keep beating this guy up here; it's unnecessary. Discovery is all the evidence that that's collected, and this consists of everything from police reports, witness statements, DNA, lab results, pictures, video, anything, shell casings, anything having to do with what was collected during the course of the investigation or at any time concerning the case. So this process itself very often is very lengthy. So it takes months, sometimes unfortunately years, to go ahead and exchange all this discovery for the predominantly on the side of the prosecution to go ahead and turn over all this evidence and then file what's called an answer to discovery, which is just a formal document typed out saying, okay, here's our answer to discovery, and most of it says, okay, this was turned over, this was turned over, this was turned over, and they get what are called discovery receipts, which basically they turn over bits and pieces of the discovery, and your attorney signs off on those receipts saying that he or she acknowledges that particular discovery that was turned over by the prosecution. Anyway, many people throughout this process get really frustrated because they're so mentally, emotionally, and very often financially committed to their case and involved in their case. And when I say financially, hopefully you have a self-defense plan, and one of these entities, as I recommend, USCCA, would be potentially paying for all this stuff as you go forward for your attorney's fees. But nevertheless, there are other types of ways in which this affects you aside from financially, which mentally, emotionally, psychologically, it's draining because you're going through this whole process. It's not immediate. It takes a while. And some people say, hey, you know what? I want to expedite this. Is there any way to expedite it? Yes. In the state of Illinois, you can demand trial. Okay, there's a Speedy Trial Act, which basically allows you to say, hey, I want to try this case now. So you have to get your stuff together, or the case has to be thrown out. That's what the argument is. Okay, and pursuant to the Speedy Trial Act, and I covered this in another Need to Know, if you're locked up, they have to try your case within 120 days once you demand trial in writing. And if you're out on bond, they have to try your case within 160 days once you demand trial. But understand this about demanding trial. When you demand trial, you're saying, I'm ready to go to trial right now, which means that basically if they haven't turned over all this discovery to you and you say you're ready to go forward, they can say, okay, we're going to try this case in 2 weeks. They give themselves enough time to be able to get the rest of their evidence together. They come forward, they say, we're ready to try the case. It's 2 weeks later, the judge is like, all right, the defense said they're ready, the prosecution's saying they're ready, let's go forward with this trial. What's the problem with that? The problem is you're going to be seeing certain discovery, you're going to be seeing certain evidence that you never saw before. So it's a bit of a catch-22. You don't want to be, delaying the case. You don't want the case getting delayed for any particular reason. But at the same time, you also don't want to be caught by surprise with new evidence that you weren't aware of during the course of a trial, because that obviously would be pretty ugly situation to be in as well. So it's a balancing act. You want to speak to your attorney, because most attorneys that have experience in this particular area of law are going to show you how best to go ahead and proceed with, balancing the fact that you want to go forward with the case, and also balancing the fact that you want to be able to see all the evidence before you actually go forward with your particular case. Either way, hopefully this has been helpful. We'll talk to you soon.